Welcome. My name's Sir Geoffrey. I'm the Vice-Chancellor here at the University of York. It is wonderful to welcome you to the SLSA conference, whether you're in the room or watching from further away. And I don't want to discourage those watching from further away, but I have to say it's lovely to see people in 3 dimensions. So you are most welcome. It's my pleasure to introduce this plenary session. It's going to be chaired by Linda Mulcahy, here to my left, who is Professor of Socio-Legal Studies at the University of Oxford and Director of the Centre for Socio-Legal Studies. And she has been at the forefront of research into both the physical and, moving to tonight's subject matter, the virtual court. And our speaker is Sir Geoffrey Vos, Master of the Rolls and Head of Civil Justice in England and Wales. Sir Geoffrey is President of the Court of Appeal Civil Division and leads the delivery and development of civil justice across England and Wales. Until early last year, he was Chancellor of the High Court, in charge of the business and property courts of England and Wales. And between 2015 and 16, he was President of the European Network of Councils for the Judiciary and has been active for many years on behalf of the Judiciary of England and Wales in international relations in Europe and beyond. He's an honorary fellow of Gonville and Caius College, Cambridge. He's had a lifetime interest in social mobility, and that strikes a particular chord with us at the University of York. And he was chairman of the Social Mobility Foundation between 2008 and 11. Sir Geoffrey will be speaking to us about the challenges and opportunities of digitisation in the court system. And as both Chancellor of the High Court and now Master of the Rolls, Sir Geoffrey's been driving forward many of the moves towards a digital future for the courts. Indeed, I think you can say he is an advocate for a deep transformation of civil justice in recognition of the possibilities that new technologies open up. And as I'm sure you all do, I look forward very much to hearing his thoughts on where the courts will go next. Sir Geoffrey, over to you. Thank
you. Well, good evening, everybody. I have to start by disappointing you. For some reason, the wires have been crossed, and the digitisation of the courts will have to wait for another day. But there are literally, not dozens, but literally several lectures online that I've given on this subject, the digitisation of the courts. But there is no lecture online with the title that I've actually chosen, which is The Proper Place of the Law in a Digital Society. And that, I think, is something that is extremely important at this particular juncture. There are, I think, many misapprehensions about what the law is for, how we should regard it, and what value we should accord to it. And first, many ordinary citizens regard the law as a coercive power which they would wish, frankly, to avoid. They don't want to be arrested, fined, or imprisoned, and they think of law purely as criminal law. And secondly, and importantly, many in politics and governments and elsewhere see the law as external, and they see it even as a necessary evil. They think it's over-complex, over-fussy, and inaccessible. They try to avoid contact with it because it gets in the way, as they see it, of their ability to achieve whatever it is that they want to achieve. And thirdly, there are business, commercial, and financial people who see the law as an enabler. They need it to be able to trade, they need it to be able to invest, to buy and sell shares and properties, and to contract with counterparties. And when things go wrong, it enables them to sort out their dispute, albeit sometimes at rather too significant a cost. Now, there are many other views of the law, but very few in our society see the law as an entirely good thing, or as something that is more than a necessary but a rather cumbersome part of a well-regulated society. And it may be noted, of course, that law plays different types of role in different types of society, in less democratic societies in particular. But even there, it's probably still regarded with a variety of views by those within those societies. So my thesis this afternoon is that law is actually rather more important, rather more essential, and even perhaps more lovable than most people would think. And I use that word in the sense that it needs to be embraced by society to provide all the benefits of which it is capable. Our law, after all, actually reflects our society. It's the glue that holds us all together and makes us what we are. And it's a tool that offers even more to a digital society than to anything that has gone before. And this is something that needs much more explanation at school and university, not to those studying law, but to those who are not studying and will never study law. So let me try to explain. First, what is law? Well, law itself is far from binary. There are probably well over 200 separate and different municipal legal systems in the world today, each with different conventional and legislative foundations. Many are code-based civil law systems, others are traditional common law systems, and yet more are a cross between the two. The irony is that despite the fact that we have so many municipal legal systems operating in different states around the world, it's not always those many municipal systems that are the most important ones. The relations between states are not governed by municipal laws at all, but by what we like to call international law, which is sometimes said not really to be law at all. Large groupings of states, like the European Union or the United States of America, have created very significant EU and federal laws, which are probably far more significant to ordinary people's lives than the internal state laws. And much of people's lives is affected, if not governed, by large international corporations who operate across state boundaries and generally choose what legal systems should govern their relations both with other businesses and with consumers. In practice, they generally choose from very few of the many municipal laws and legal systems around the world. And that means that those laws and legal systems that are most attractive and most popular with big business tend to have far more influence than those that are not. And one might pick PRC, People's Republic of China law, New York law, English law, Singapore law, and in recent times Dubai law as examples. Common law systems tend to be more attractive to business in general and international business in particular because they provide a set of rules that are certain and consistent, but yet flexible enough to be adapted to novel situations thrown up by developments in society and in technology. It is their adaptability to new technological situations that is most important for the purposes of what I'm going to say tonight. So I'm going to return to that theme. The second aspect of law that is critically important to its success is its use as a tool for regulation. And I use the term regulation in its broadest sense. Regulation in federal states tends to be imposed by federal as opposed to state law. Regulation derives its authority from law and is crucial to the stability of markets and society. Regulation of energy prices is something topical right now. Without it, economies would quickly destabilize. Law also underlies the regulation of financial markets. It underlies banking, competition, and trading in commodities. We can see what happens in such international borderless markets without regulation when we look at the vast unregulated trading in Bitcoin and other crypto coins and tokens and in decentralized finance or DeFi. Now, the size of these markets is now, according to President Biden, in his executive order of the 8th of March this year, 8th of April, I'm sorry, 8th of March, forgive me, definitely the 8th of March, some $3 trillion. And the markets are driven by the desire for disintermediation, something that has always sounded wonderful, but is far less easy to achieve and perhaps less beneficial than many until recently thought. We are already seeing a transformation in the digital space as more and more mainstream investors and businesses start to adopt digital technologies, specifically smart contracts, crypto assets, and the blockchain. There is a need for effective and agile national and international regulation. The unregulated digital sector is gradually being brought within a regulatory environment. But the way in which that transformation is taking place is essential to my theme today. The point is that many of those who invest in crypto assets and DeFi are in fact the same people who work and operate in mainstream society. They want to invest in regulated assets that provide security and the availability of legal redress for misconduct. They even, in most cases, amazing though it may sound, are happy to pay taxes when they are due. Now, the third piece in the jigsaw is perhaps even more fundamental. Law is important because it is the foundation of democratic society and the rule of law itself. And Lord Bingham identified the main features of the rule of law, several of which I've already mentioned in different contexts. The need for the law to be clear, predictable, and intelligible, rights being determined by law rather than discretion, laws applying equally to all, public officials acting intra vires, the protection of human rights, the state providing effective and fair dispute resolution, and the state adhering to international law. But the rule of law, as I've just described it, is really one of the most misunderstood concepts. Not only do politicians often fail to understand its ramifications, but even some lawyers confuse rule by law with the rule of law. The rule of law is not about how many people are prosecuted or how law-abiding citizens may or may not be. It's about the power of the state being regulated by a legal system to which every citizen has access. Now, people generally don't see the rule of law as the cornerstone of a democratic society, which is what it actually is. And they perhaps don't need to understand, but we certainly do. The rule of law is important because if you have it, ordinary people have confidence that they will be fairly treated. Ordinary people will have confidence that the government will treat them fairly, that their employers will treat them fairly, and the police, the local authority, the courts, big business, Amazon, Google, and everyone else will treat them fairly. Now, that public confidence is central to a successful society. Without it, people either live in fear or at least without the necessary motivation to be economically and socially productive. In a digitized international society, the rule of law becomes even more significant, and I will return to the relevance that it has in that context. So let's look at law in an international society. And I've already touched on international law more than once. But here I'm talking about how law affects the cross-border world in which we now operate. Now, multinational corporations like Facebook, Apple, Netflix, Google, Alphabet, and so on are highly significant because they provide a large proportion of the world's population with access to the internet, with access to consumer goods, to smart devices, to entertainment, and to social media. And in doing so, these corporations reach into the social fabric of all our lives. And it's axiomatic that they cannot operate unlawfully and in an unregulated environment. Yet, many think that in some senses they do. Their liability to tax is dictated by the efficacy of national revenue systems in an internationalized world. Their accountability to state governments may be thought in some ways to have been compromised, and yet their influence on a large percentage of the world's population is huge. But law in an international society is not only about multinational corporations. It's about cross-border technologies that do not easily lend themselves to governance by any specific municipal system of law. And in a world of artificial intelligence, of the growth of the blockchain, of the Internet of Things, of data about every citizen of every country being far more easily gathered and utilized, the regulation and legal foundation of this global environment is more problematic than many might have imagined a few years ago. So I want to come to the burden of my song, which is about law in a digital society. And one might ask whether we can any longer ignore or fail to embrace the legal foundation of our societies in the modern world. And the digital society of which I'm talking is an environment in which the internet and the data that it creates continue to grow exponentially. It's an environment in which we will see, whether some like it or not, the ubiquitous use of smart, machine-readable documentation in place of analog programs such as PDF and Word. It's a world of smart legal contracts recorded on-chain, and central bank digital currencies and stable coins, increasing both the number and speed of transactions globally. It's a world in which everything that every consumer and every business does will be recorded immutably and eternally on-chain. And of course, our lives will be increasingly dominated by the use of artificial intelligence. It will be a data-driven international society. Frankly, it is already. Now, in this environment, the law must play an even more fundamental part than it did before there were 4.6 billion internet users in the world, as there are today. And that 4.6 billion figure is growing every day. It's almost 60% of the world's entire population. As I said, there is now a move from unregulated to regulated digital activity. Bitcoin has become larger and more popular than anyone expected, but in the longer term, its inevitable volatility and instability is going to put off many, if not the majority, of the world's investors and businesses. Regulated use of smart contracts and blockchain technologies will take off as soon as central bank digital currencies and stable coins, smart documentation, and electronic transferable documentation themselves become ubiquitous, as they inevitably will. Now, as examples, Bitcoin and investment may sound a long way from the real lives of ordinary people. But the shift to new technology, especially the blockchain, will be apparent sooner than you may think in many, if not most, fields of human endeavour. It will affect how wages are received and taxes are paid, how workers' rights are protected, how food is supplied, and how property is owned and transferred. The question is how this regulation will function in the fragmented legal world about which I've spoken. Now, I've worked hard recently, in recent years, through the UK Jurisdiction Task Force to prepare English law, at least, for these developments. We published in November 2019 a legal statement on the status of crypto assets and smart contracts under English law, which has received, I'm pleased to say, judicial approval, not just from me, but in various jurisdictions. It makes clear that crypto assets are properly to be regarded as property in English law, and that smart legal contracts are indeed legally binding contracts in English law. It doesn't sound very revolutionary, but actually it is. And in April 2021, the UK Jurisdiction Task Force published its Digital Dispute Resolution Rules, intended to make it easy to resolve disputes that arise from on-chain digital relationships and smart contracts. The rules provide for arbitral or expert dispute resolution under English law in extremely short periods of time for digital and blockchain disputes, and they allow arbitrators or experts to implement decisions directly on chain using a private key, and they allow, in a revolutionary way, for the anonymity of the parties. And finally, in February 2022, just a few weeks ago, the UK Jurisdiction Task Force published its Smarter Contracts report that explains how smarter contracts and blockchain technology are currently being used. So it's perhaps worth pausing there for a moment to explain the reason why I've been so keen to lead the UK Jurisdiction Task Force in the context of LawTech UK. And it is because, as I see it, the legal foundation to the rapidly accelerating digital world is not only desirable and inevitable, but provides an important opportunity for the UK and the UK economy. And all that I've said thus far may be important, but it doesn't explain exactly how the law can move in a digital environment from being a necessary evil to a valued part of the infrastructure. It's necessary in the first instance just to stand back. In my lifetime, the way people live their lives has changed beyond any kind of recognition. The internet, global corporations, social media do not provide services that are any longer either luxuries or optional extras. Their value and the effect that losing these things has on a world population has become all too clear during the tragic events in Ukraine and Russia in the last few weeks. The 4.6 billion people I've already mentioned actually need access to a digital environment. It's not an optional luxury, as consumer transactions, for example, for the supply of energy and telecoms are recorded on-chain, and as banking and financial services travel in the same direction, the people I've mentioned will also need stable and reliable access to blockchain technologies. Stability in access to digital technologies, just like stability in the value of crypto assets, can only be provided by legal infrastructure, allowing for the speedy resolution of digital disputes fairly at proportionate cost, allowing for access to justice and a level playing field. And as I've said, law is undervalued because there is a failure to understand what it's for. It's obviously valuable in the prevention and prosecution of crime, but it's less obvious that it's required to regulate the environment in which 4.6 billion consumers and millions of national and international businesses, SMEs and micro businesses operate all over the world. In my view, the digital revolution, if I can call it that, without being accused of over-dramatization, will focus debate on the legal foundation for the technologies on which all our lives already depend, and will come even more to depend. It's most likely that the range of municipal laws that are candidates for the role I'm talking about will narrow. Now, I've mentioned some already. One law will obviously not govern everything, but everything must actually be governed by some law. In the European Union and the United States, different laws already govern private transactions and regulations, as I've already mentioned. EU law and federal law govern competition, govern market regulation, whilst national laws and state laws govern private law transactions, whether by choices of law and jurisdiction being made or otherwise. There are therefore good reasons for legal and regulatory infrastructure such as financial stability, access to justice, and service reliability. It's also necessary that the legal systems themselves are dependable and fit for purpose. And that's why I always come back in these discussions to the value of English law. And a recent report by the economic consultancy Oxera for Legal UK explained that English law governs trading in 600 trillion euros worth of OTC derivatives annually, in 11.6 trillion euros worth of metals trading, 250 billion pounds worth of M&A deals, and 80 billion pounds of insurance contracts every year, just to give a few examples. There are many more. It's important that English lawyers and our government understands that English law can also provide the legal infrastructure for the new digital technologies of which I've been talking. It has, that's English law, has the necessary stability, flexibility and certainty, and more important than any of that, English law enjoys international confidence. And there's a further point here about the rule of law. What one might regard as compliance with the rule of law is obviously state-specific. Consumers and businesses can only vindicate legal rights under their local municipal laws. If the court system is not fair or is not available, the value of that legal system is significantly reduced. However excellent the system of law might objectively be, if I wanted to be controversial, I could give some very significant examples, but I won't just now. And the reason English law is so valuable is precisely because the system is accessible, is applied fairly, and does therefore attract the confidence of national and international consumers and businesses. And I might interpose here that the reason why I have hopefully been in the vanguard of the creation of a digital justice system is so that in our country we can continue to have access to justice for all persons at affordable cost in a reasonable time. And that can only be achieved by putting justice online, because otherwise it is too expensive, takes too long, and is simply inaccessible. Now, in a groundbreaking keynote speech last Monday, John Glenn, who's Economic Secretary to the Treasury, said some extremely important things in this connection to innovate Finance Global Summit during FinTech Week for 2022, 100 years out of date. And I don't think they were talking about crypto technologies in 1922. But he said that if crypto technologies are going to be a big part of the future, which I can say they are, then the UK wants to be in and in on the ground floor. I respectfully agree. He said that if we commit now, if we act now, we can lead the way. Again, I respectfully agree. And he said that the Treasurer's response to its consultation on stablecoin confirmed that legislation will bring certain stablecoins into our payments framework, creating the conditions for stablecoin issuers and service providers to operate and grow in the UK. Jolly good. The government will also be looking, said Mr. Glenn, at regulating a broader set of crypto activities, including trading of tokens like Bitcoin, and will be consulting on a world-leading regime for the rest of the crypto market too, a regime that will facilitate safe and sustainable and rapid innovation. 3 cheers. More important than any of that, however, Mr. Glenn referred to the legal landscape, explaining that it will be crucial. He said that English law and our world-leading legal services and courts are already a huge asset and can play a big part in making the UK an attractive hub for all things digital and for new technologies more generally. And he referred specifically, I'm delighted to say, to the work of the UK Jurisdiction Task Force and the Law Commission, concluding that he was asking the Law Commission to undertake a new project on the legal status of decentralised autonomous organisations, or DAOs, and that English law can and should provide the legal foundation for the use of these borderless technologies. I wonder who he'd been talking to. So return then to my thesis. Anyone looking at the trajectory of change in consumer and business technologies will be able to see how vital the legal infrastructure is going to be. It is, as I started off by suggesting, the glue that will hold the international consumer and business world together in our new environment. But lawyers need to explain to the world how critical that glue will be to protecting real people when they are increasingly dependent on the digital systems and on data recorded on chain. The reality is that such digital systems will be governed by law in one form or another, whether English law or other laws, or no law at all. The risks of the latter solution are absolutely massive, as the size of the existing unregulated DeFi market already shows. That possibility does simply not sufficiently alarm large numbers of individuals around the world, but it should do, and lawyers and others need to make the case more strongly than they have so far. So let me conclude by trying to draw some of the threads together. The things that are important to people have changed dramatically in less than 2 generations. The connections between life in different states and different countries are much closer than they were even 20 years ago. The legal community has not been as good an advocate for itself as it could and should have been. It has failed to explain, or perhaps failed to convince, a large enough proportion of the population as to why law was important in an analogue world. But for the reasons I've been trying to explain, it will be even more important in the developing digital age for the legal community to explain why law is so critical to the success of societies of the future. The massive increase in data and connectivity will make it imperative that the law underpins the technological edifice on which everyone will depend. I've not mentioned either hacking or cybercrime, but both obviously pose huge risks to our digital futures. But I always argue that we should not halt digital development. In fact, we can't halt digital development because of a fear of cybercrime. Instead, we should make sure that we make cyber security our highest development priority in the context of a regulated digital environment underpinned by the foundation of law. So cybersecurity, alongside the need for financial and platform stability, provide excellent reasons why the law will be far more important in the new digital world. Law and regulations will bear a huge responsibility for the success of the digital developments I've mentioned. English law, in particular, can play a major part if its advocates are sufficiently persuasive as to its virtues. Neither English law in particular, nor law in general, will succeed, however, if it does not persuade the consumers and businesses of the world that law is an essential support, not something they can simply take or leave at will. Thank you.
Sir Geoffrey. And Sir Geoffrey's very kindly said that he will take some questions from the floor, lots of challenges for us in his speech tonight. We've been very well looked after. We have two wonderful students who are going to be running up and down the stairs to bring mics to you. So if you'd like to raise your hand if you have a question, we can get the discussion going. And would you mind saying who you are before you ask your question? I think it's Jack, just at the back. Thank you. While the mic is going up there, I'll just mention I'm also taking questions online if anyone's zooming in from outside, so I will be keeping an eye on that as well. Thank you. Jack.
Hi. Yeah, thank you. I'm Jack Head. I'm a PhD student at the Centre for Socio-Legal Studies in Oxford. Thank you for a really illuminating lecture. You suggested at the beginning of your lecture that our law reflects society, and I'd just like to ask, if I may, how judges know that this is the case. It's been noted by Jack Beatson that the late Supreme Court Justice Lord Roger left a bequest to Glasgow Law School, but on the condition that none of it be spent on criminology or socio-legal studies. And it's also been argued by a number of scholars that the use of empirical data by the UK courts is unprincipled and unpredictable. Obviously we're here at the annual conference of the Socio-Legal Studies Association, and many of us carry out research into the courts in this and other jurisdictions. But I think many also have a sense that the courts themselves are considerably less interested in that work. So I just wondered whether you could tell us what your views are about the importance or not of socio-legal studies, and whether you think those are shared by your judicial colleagues. Was Alan Roger an outlier, or is there still a degree of uneasiness towards this field within the judiciary?
I have no idea. It doesn't arise from anything I've said, but I think there may be suspicion of socio-legal studies, but if so, I'm not aware of it. I think if judges are not interested in the society they serve, they're making a big mistake, because law and the courts and the court system and the whole infrastructure about which I've been speaking is absolutely essential to a modern society. So the idea that one can ignore the society you're serving and simply concentrate on legal decisions and legal thinking is simply wrong. And so you won't find me saying anything of that kind. I actually think judges do a lot of thinking about social issues. I think the development of the law is conditioned by social issues. I think the common law is peculiarly effective at dealing with social changes in our society, because it is a system that depends upon each case that is thrown up by what actually happens in society, not by what happened in the past. And so it develops incrementally to deal with different social and commercial situations. And that is a tremendous benefit. If you have a code system, as many countries in Europe do, you don't get that benefit. You are forever interpreting something that was written ever longer ago. So I think our common law system is quite well adapted to deal with social changes. I think judges would be making a huge mistake if they didn't take those changes in society and the interests of the society they serve incredibly seriously. But that's only my view.
Thank you. Anyone else? Yes, Robert. Just here, the dark jumper.
I should perhaps preface these remarks by saying that I'm a sociologist rather than a lawyer, and as Linda and I go back a very long way, she can fill the crowd in on the details as necessary. I very much welcomed your emphasis on the creative power of law. In the days when I was attempting to encourage rather vainly sociology students to have an interest in the sociology of law, I'd get the daily papers out and distribute them to the class and ask them to find the law. And of course they turned to the crime reports, and it took a little intervention to persuade them that they should actually be looking at the business pages and the sports pages and more or less anywhere else in the newspaper, and they would find the law, and it made all of these other things possible. But the thing that gave me some pause in your remarks was that, if you like, the decoupling of the digital age from a material base in any particular nation state, and the extent to which it becomes possible to capture the sort of events that you're describing about. The law is at the one time necessary for the foundation of a digital society or a digital economy, but at the same time that is very elusive and prone to escape across national boundaries, or even in the minds of some fantasists, to go entirely offshore or indeed off-planet. And I'd be interested in your thoughts about how one actually ties this down, and we come back to the issue of the citizen in Britain, in the high street, who is attempting to negotiate a transaction with some reasonable degree of certainty and the promise of a machinery for resolving disputes should they arise. Thank you.
Well, fascinating, thank you. Fascinating thought. The question of decoupling is extremely complex and developing at a fairly rapid rate. We've seen the growth of internationalism, which I said something about, and we've seen the retrenchment of internationalism as we've seen nationalistic governments elected in many countries around the world. We've seen the growth of global corporations, and we've seen the attack on global corporations. And we've seen national states retreating into themselves, and we've seen others entirely dependent on the internationalism I spoke about. So it's a hugely complex situation, and I don't think the show is in any sense over. But my thesis, which I think is extremely important, is that the new technologies will affect every person in the high street as much as they will affect Amazon or Facebook or global corporations or global governments. And the reason for that is that something that people really don't understand, and maybe I didn't make clear enough because I tend to say it quite often, and so I'm perhaps assuming prior knowledge, but the blockchain is a technology that will be used in every sector of our lives. So if you have a gas bill, your gas bill will be recorded on chain. Your gas consumption will be recorded on chain. and it will be known for all time what gas you consumed, how much it cost, and whether you paid for it. And that's the same with telecoms, it's the same with relationships between telecom corporations, it's the same with pharmaceuticals, with financial services, with the rates, and everything that affects individuals. So the database is growing exponentially, and it will not be possible for the transaction that an ordinary consumer enters into and gives rise to a dispute to be resolved without understanding and accessing that digital environment. And so our legal foundation for the new technologies is going to be critically important. And the number of laws that actually govern those technologies is going to be considerably less than people think. And English law is probably one of them. English law is peculiarly well placed globally, particularly because of some of the international tensions I've been speaking about. The US has had certain issues. We need to discuss what they have been, but the confidence in the US is perhaps not as high now as it may have been in the past. European laws are not attractive for one or two of the reasons I've already mentioned. Singapore law, has issues about it. Very small jurisdiction, doesn't have the same depth and reach, and so basically English law looks good internationally. And therefore, when you look at the blockchain, which is entirely borderless and will govern even the gas bills in as much in York as in any other country or any other town anywhere else, we're going to have to look internationally. So I think it does affect consumers. I don't think it's unrealistic to say that the legal foundation of the new technologies will be fundamental to society as a whole. How it will work out and how the interaction between some of the changes I've mentioned actually demonstrates itself in 20 years' time, well, I've left my crystal ball in London.
Yeah, I'm sorry, I did promise the runners that I would go from side to side. I think there's a question just at the back there. Ellie.
Hello. Oh, sorry. Thank you so much for your talk. I'm Ellie. I'm also a PhD student at the Centre for Socio-Legal Studies in Oxford. And I was very interested in the concept of failure that you invoked during your talk. I thought that was really interesting, particularly a failure to understand law and the legal system. And I was wondering whether you might expand on what you meant by the term failure for us, and particularly how much this kind of failure might lie within the legal system itself rather than those who don't perhaps understand the legal system or those seeking to understand it. Connected to that, I wondered how you might envision law being made more understandable to people and the wider public.
Well, if I may say so, another excellent question. Of course, the responsibility for failure to understand law lies within the legal community and the legal system itself. But what I'm saying is that we have to completely change our approach to explaining ourselves as lawyers, as judges, as academics in the legal field, because law is much more important, much more foundational in a digital era than it was in an analog era. It was pretty foundational in an analog era, and we did fail to explain its importance to people, and people didn't understand it. They regarded it in the way that I said in my lecture. So how do we do it better? The answer is to make it more accessible. One of the problems is that if you have a legal problem, most people don't understand it is a legal problem in the first place. In many, many cases, whether it's a family law problem, a medical problem, an employment problem, and you can go on and name them all. And people don't think immediately they've got a legal problem. They say, my boss is being nasty to me, or my doctor didn't treat my bad toe, but they don't see it as a legal problem. And so accessibility has to be made far, far easier and better. And that is why digitisation of the courts, what I call the digital justice system, is absolutely critical. And I'm pleased to say that is happening. So we are going to have legislation has been put in place and will be getting the royal assent shortly, a digital justice system whereby every claim you will be able to go to a website or an app which will direct you to the place where your problem can be resolved very simply and very easily, and individuals will be able to do it. It'll be directed not at lawyers, it'll be directed at individuals. And law is all about problem solving, and you have to know you've got a problem before you can solve it. But at the moment, there is nowhere where you can go to find out how your problem can be resolved. There will be, and that website, that app, will point you to the correct place to get that problem resolved, again probably at no cost, by a portal, a pre-action portal, so there won't be you will simply then try and resolve it with whoever it is, whether it's the state or your neighbour or your spouse or somebody else, and you will try and resolve that problem, and it'll be done very quickly online, as happens at the moment with ombuds processes and various other structures. And only if all else fails will you go at the bottom of my funnel by a digital process, an API, an application programming interface into the court system. Now, that always has to be available, but it actually needs to be used in a vanishingly small number of cases, because most people's disputes are tiny. And I always say 60 million disputes every year are resolved on eBay by artificial intelligence or whatever. So the most important thing is for people to understand that they can resolve a problem simply at proportionate cost, in the right place at the right time, without delay. And we are beginning to achieve that. It was unheard of a few years ago, before we had the internet, before we had everybody with a digital device in their hand every moment of the day. But now we do. And the other thing I always say is that people of your age, I'm not looking at the professors in the audience, but people of the students' age, understand that everything can be obtained on this, everything. And it's an absurd situation if law and justice is excluded from that availability. And it won't be, and it isn't. Now, you may realise I'm not the most popular man in the legal community, because people say, well, what about lawyers making money, and what happens if we can't charge for legal advice? People can go online and get their problem resolved, they won't need us. And I always say to lawyers, that's nonsense, that lawyers should be paid for adding value, and there'll be millions of cases actually as the world becomes more complex which will require proper legal advice. But we should not have a situation where people can't access justice for lack of funds, and a digital justice system will revolutionise the accessibility of remedies, of vindication of legal rights, quickly, easily, and without delay. And so I feel extremely strongly that what I'm talking about is a failure of the past, and that I am hopeful that there will be in the future success.
Thank you. A colleague in the green shirt, just on this side, on your left, 6th row down. If you wouldn't mind putting your hand up, thank you.
Thank you so much. That's really, really interesting. So I'm Laura. I'm a lecturer based at Keele University, and my question's a bit more on the technical law side of it all, or governing law and tech. I echo exactly what you were saying about the importance of having access to the internet and in particular social media, particularly when you look at what's happening in Russia and the Ukraine at the moment. It is vitally important. But then if you look at that through the government's recent online safety bill, where they're going to impose obligations on social media companies to remove legal but harmful content, how does that uphold the rule of law? And we know, especially with tech law, that there is this bit of copy and pasting in other countries. and where democracy might be a bit more fragile, if other countries look to us and copy and paste that legal but harmful approach, are we not impinging on the rule of law more than actually protecting it?
Well, you know as well as I do that the rule of law is not an absolute in any sense. A few years ago, the American Bar Association astonishingly introduced something called the rule of law, I can't remember what the word was, but a monitoring system which judged all countries and gave them a score for whether they adhered to the rule of law. Astonishingly, under that system, America got 100 and everybody else got less. Obviously, I mean, I'm not even sure that's quite right, but it's close to right. And when I was chairman of the bar, I spoke at a conference in somewhere, San Francisco, somewhere in America, and got myself in awful trouble by suggesting that there were certain aspects of American governance, like Guantanamo Bay, that might not have given them 100% score on the rule of law indicator. It was the indicator at the time. Now, so I don't think you can say that just because you introduce an online safety law which restricts freedom of expression, obviously in some respects, that the rule of law is that it completely abrogates the rule of law. What happens, of course, is that it's a balance, and you need some protections for people. People need to be protected. You can't have a complete free-for-all in life, and then others will argue that the protections that are introduced go far too far and restrict people's freedom, accessibility to justice, and so on. So, I mean, actually the rule of law is about, at the fundamental level, is about fairness. It's about fair treatment. And it's about being able to get an independent resolution of any dispute, which in most countries you can't, either because you can't afford it, or because it's not available, or you have to wait too long. I mean, in many European countries, even well-regulated European countries, they have millions of backlogs in the courts because they don't restrict the right of appeal. So you can take your parking ticket to the Supreme Court. Well, that's obviously absurd. So the point is that everything about the rule of law is a balance. But in my view, we are going to have to look at the rule of law in a different way in a digital society, and it's going to be very difficult. It's going to give people very difficult choices, and much of it will be determined by the borderless technologies. And the amazing thing really about the blockchain, which is coming and coming fast, I always say, I was told that if you look at the graphs of the growth of the use of blockchain and the growth of the internet, plot them against one another, we are now in blockchain where the internet was in 1995. Now, some of you perhaps weren't born in 1995, but I was, and I remember very well that the internet was definitely not going away in 1995, and nor is blockchain. So when we see how this develops, and we see how nation-states respond to the new technologies and what legislation they put in place, it'll be extremely interesting. I mean, I'm passionate about the UK leading the way, not because I'm interested in world domination or anything of that kind, because I think that English law has something very strong to offer, because it is a good system, because of all the things I mentioned in my talk. So I don't think one piece of legislation will destroy the world. I think it's a balance, and I think that we're going to see the significant changes in our approach. If you had me talking in 10 years' time, if I happened to be still alive, I think I would be able to help much more as to how those developments are panning out.
Thank you. Yeah, there's a question right at the back in the back row. Thank you.
I'll stand up since I'm slightly buried back here. I'm Michelle Hughes. I'm a PhD researcher at the London School of Economics. And I'd like to kind of shift your focus for a moment to legal education and the implications with that in what you're talking about. I happen to sit on the board of an NGO that does tech for justice, or has attempted to do global programs to use technology in order to fill justice gaps, particularly in developing countries. And one of the ongoing challenges that we've had in looking for effective and sustainable programs is the fact that the technology is changing so quickly that even the advocates, even the ombudsman cannot keep up, particularly when we're starting to talk about things such as artificial intelligence and machine decision making. The transparency level is not getting greater as it's advancing. It's becoming less and less and less, to the point where even the companies that produce apps for things such as third world lending and financial services don't even understand their own algorithms and have outsourced that to one or two algorithm or risk analysts who are also technicians. So with these kinds of challenges, what do you see as the future of legal education to prepare us as lawyers to advise and address all of the challenges of the rapidly advancing digital environment?
Well, yet another excellent question, thank you. I agree. I've said for many years that legal education needs radical rethink. I don't think that lawyers need to be trained in the technology and need to understand the algorithms or the artificial intelligence, because you wouldn't get any lawyers if everybody needed to be both a computer scientist and a lawyer. I do think that lawyers need to understand the real world rather than the world of 1873, when the Judicature Act was passed and we established our current legal system. So I personally think we need a radical overhaul of legal education. I think it's absolutely astonishing that most legal courses are similar now to when I went to university in 1973. And I think it's a bit of an indictment, to be honest, of the speed at which legal thinking moves. What should lawyers learn now? As I say, they don't have to learn how to actually operate they need to know how to use technology, but they actually need to understand how the world is working now as opposed to how the world worked before. And lawyers are incredibly ignorant about the way business is already utilizing technology. If I had a penny for every time one of my colleagues has said to me, we must be careful about how we use artificial intelligence because we need to understand what it's being used for and why, and if we don't, we should simply stop its use. Well, you know, every single time you sign onto your iPhone, artificial intelligence is engaged within milliseconds of anything you do. And so the idea that we can in some way stop its use is absurd. And so lawyers need to get with the program slightly and understand that we already have smart programs, we have artificially intelligent programs, we have algorithms, as you say, operating in every aspect of our lives, and we need to make sure that lawyers are giving legal advice in relation to the environment in which we really live rather than the world of Donahue and Stevenson. And you know, Donahue and Stevenson's a jolly good case, and we still teach it at university, and of course the students probably still like it, but actually, do they really need to know about that, or do they need to know some much more fundamental understanding of how the world operates today? I don't know, I'm not a legal educationalist, I don't pretend to be able to design the course, but I'm absolutely convinced it needs to change.
I think you might be talking about my university when you're doing that, but it's almost sacrilege to say it at York, which has one of the most progressive law degrees, which I'm sure you would like to learn more about. I'll leave that to Caroline. Yes. There are real innovators here. So I think we're due a question over this side. Yes, colleague in the check shirt, just near third row up. Thank you.
Now I'm an example of somebody who was around in 2015, and my boss sort of said, oh, we've got this new thing called a computer, you deal with it, because I don't want to look at it. In my experience working in welfare rights, one of the problems is that you've got a small section of the population who find digital advice and digital access very difficult. I think in a recent survey we found that 30% of our clients had no independent access to computers. And I can sort of bore on for hours about examples of clients who've actually fallen out of the system because of lack of access. So I'm just wondering, in the great world of apps, which I'm really enthusiastic about, how do you mediate that for certain people who are always going to have difficulty at that kind of level?
Well, I mean, of course you're right. I nearly every speech I give, I have a section in it in which I say, of course you must make sure that those that are vulnerable or digitally disadvantaged are properly catered for, because it's absolutely imperative. You can't have access to justice for the digitally enabled and no access to justice for the digitally disabled, if that's the correct term. So I'm completely with you on that. And I also understand that the lower down the pecking order you get, the greater the percentage of people who are digitally disadvantaged and unable to operate even the simplest of digital systems. However, I believe that percentage will probably decrease. I believe that you should not design systems for the least able. You should apply interventions to make sure that the least able are brought up to the situation of the most able, which is looking at the problem the other way around. It would be betraying those who are the majority, who do everything on this and are perfectly able to write a 140-character tweet in about a millisecond, if you did it the other way around. I mean, when I talk to my colleagues, which is quite frequently, particularly digital judges, district judges around the country, not very often digital judges at all, I say, you know, the new digital justice system, whether it's online civil money claims or whatever that they're dealing with, I say it's very easy to operate. And one said to me once, do you know, in order to access the system and get a document up, I have to do 5 clicks. And I said, well, have you seen how quickly your child or grandchild does 5 clicks? And have you seen how quickly they do a 140-character tweet? And he said, yes, but I can't. And I said, well, you're a judge, you better learn. And there is, of course, a difference between different people in society. But there are more people who are going to be like the young people I've described in the future, and less people like the judge I've described. And even the vulnerable, who obviously are the ones that are already failing in dealing with the ever-complex systems of our society, will always need to be catered for, but that's not a reason for not making a better system for the majority. What we need to do is to make sure we don't allow those people to be left behind under any circumstances. And that's all about social service.
Thank you. There's another question right at the back, sorry. Last row on your left.
Thank you. I'm Sophie Vigneron from Kent Law School in Canterbury. So I'm French. I would just say just one word about the French. I think we should not underestimate the creativity of French judges when it comes to the interpretation of the civil code, which was reformed in 2016, the contract, but that's just neither here nor there. But I suppose I just want to pick up on what you just said about social justice, and we should bring the poor or the less educated society up. But in your talk, you kept talking about the digital space, the unregulated digital space, which has no border. So how is it going to be possible to legislate or regulate that digital space and protect the less digitally able who are actually not in the UK but are in another country. Because if I understand correctly, but I might be mistaken, you're saying that this unregulated space, the internet or bitcoins or whatever,
DeFi.
Sorry?
DeFi, decentralized finance, yes.
Is everywhere in the world. So it's how is it going to be possible for English law to protect those that are not as able or aware, but actually are not cannot benefit from social services in the UK to bring them up? How are you going to protect those consumers who are not here, but who will be regulated by English law?
Well, it's not just English law. I mean, I'm in England and I'm an English lawyer, so I talk about English law, but French law, as you rightly say, is perfectly capable of regulating all this, and some will use it and some will not. So don't take it as an affront just because I'm talking about English law in England. English law does happen to be useful and used overseas. But the substantive question is a really interesting one. And I tried to address it slightly in my talk. The problem is the borderless technologies, and the problem is that many people are prepared to invest apparently $3 trillion a year in technologies that are not regulated by any system of law, and where there are no real remedies, and where the investment is extremely volatile to the point where it may overnight become totally devalued. That's unsustainable in the long term. And what lawyers have to make clear and governments have to make clear is how the digital space is going to be regulated. And I think there are a number of changes that will be transformational in this development. And first of all, I did leave my crystal ball in London, so I can't tell you precisely how things will look in 10 years' time. But if you asked me in 10 years' time, the digital space will be regulated, not over-regulated, but regulated. The reason why $3 trillion a year is invested in the unregulated space is disintermediation. People objected to lawyers, bankers, financial services consultants, custodians, pension people taking a share of their money. And so when the digital space arose, they thought, now I can invest without any of those intermediaries taking a share of my money, and I much prefer that. I feel more in charge. And that fails because of the volatility of unregulated investments and because they're not pinned to real assets. And so what the central banks are doing is looking at the current situation and saying, how can we ensure, and this is all about money ultimately, how can we ensure that there can be digital transactions recorded on the blockchain like Bitcoin or Ethereum or others without the volatility, instability and risk that consumers face from the present arrangements. And that is the direction of travel now. Now the Treasury, as I said, John Glenn announced on Monday that they're going to legislate for stable coin. Now stable coin is not a central bank digital currency, so it's not backed by central bank assets, it's not backed by, like, the pound in your pocket, it's not backed by gold in the Bank of England, but it is backed by real assets. Stable coins are backed by real assets and regulated by law. So that will be transformational when you can invest in digital currencies and you can transact on-chain with a system backed by a system of law with rights and remedies rather than really backed by no regulatory environment. So the way in which, Britain's doing that, other countries are doing it. President Biden issued his executive order on the 8th of March saying how he was going to investigate issuing a central bank digital currency with a US dollar. If they did that, that would be transformational in the digital environment and the regulation of people's risk by trading digitally. In China, they've already trialled their digital currency, and the events in Ukraine and Russia may, for all I know, accelerate the issue of that digital central bank currency. So the first development that's going to change everything is the existence of asset-backed, either stable coins or central bank-backed digital money. And that will allow on-chain transactions that are regulated by law. The second thing that will be transformational will be the use of smart documentation rather than paper and analog programs. And my joke that I say to anybody who will ever listen, and it's not very funny, is that the end of the word is nigh. And the end of the word is nigh because lawyers absolutely love an analog program called Word, invented in 1983, because they've been using it for so long. But in fact, it is really counterproductive to both law, regulation, and everything else, because it gives you no data, tells you nothing about what's in the document. You have to read it, you have to have armies of lawyers, it's expensive for consumers, it's expensive for businesses, it's a nightmare. So we should be using smart documentation. We already are in many industries. Contract automation is huge now, completely changing the landscape. Likewise, transferable digital documentation is being legislated for in this country, or will be. The Law Commission has reported on it, and that will change the landscape, the digital environment, and the regulation of the digital environment, because you'll be able to have bills of exchange, bills of lading, all international documentation governed by law and done digitally. So, and I can go on. But as governments start to sign up to the use and regulate the use of these new forms of trade and data recording, there will be more protection for ordinary people in the adoption of these technologies. And the $3 trillion, I believe, will come on into a regulated environment imperceptibly. It already is. And if you talk to lawyers who are really involved in digitization and really understand what I'm talking about, and I do quite frequently, those lawyers explain that their clients come to them every day and say, I am uncomfortable. I'm digital through and through. I absolutely love, having a flutter on Bitcoin or whatever it might be. But actually, I've got a big business now. I want a regulated environment for my digital investment and everything else I'm doing in my business. And of course, all businesses ultimately serve consumers, and so the consumers will be in the same place. So I'm not as pessimistic as you. I think, as I said before, I don't know what 10 years what will happen in the next 10 years. But I think if we were talking about this subject in 10 years' time, it would be very clear how that regulatory environment had been achieved in the cross-border world, in the borderless world. I think with some laws predominating, actually. I think you won't have a world where the digital space is governed by the law of El Salvador or Honduras or whatever it might be. I think it will be just a few laws, probably French, German law, English law, New York law, Chinese law, and so on, but it'll be a few, not many. And I think it'll work. I'm an optimist. You should be pleased to hear.
So Geoffrey, I'm going to give the last question to somebody who's an online participant, which seems wholly appropriate tonight. And they've asked a question that would be a really great exam question for a first-year legal method exam, actually. Is the Doctrine of Precedent the best way for the legal system to regulate these rapidly changing scenarios that you've been talking to us about tonight?
Well, it's a wonderful question. And it's one that's peculiarly appropriately directed at me. Some lawyers amongst the audience will have seen a judgment I gave in the Privy Council in which I advocated the incremental development of the common law by the use of the doctrine of precedent rather than the idea that the majority of the Privy Council, I was in the minority along with the President and Vice President of the Court, but we were in the minority, and the majority decided, I would say, I don't want to be rude, but they decided to rewrite the law of injunctions in that case without it needing to be decided in the case. So I feel very strongly that the doctrine of precedent shouldn't be thrown away without having something to replace it. Is it sufficiently adept to cater for the developments I've been speaking about? Ironically, yes. Ironically, the common law is, the doctrine of precedent is what makes the common law A, certain, because you know what it is, because you know what the last case decided, B, flexible, because it is a set of rules that can be applied to any situation, however novel and innovative, and C, agile, because the situation can change dramatically and the new case that comes will be decided according to the same rules that have been applied before. So it works, but it only works if there are enough cases coming through the system. And one of the very interesting things about the doctrine of precedent is the countries in the world that have got their own Supreme Court, and this is mostly common law countries, but don't have enough cases coming to them. And there, the common law doesn't always work very well, because if you're in a country where the Supreme Court only hears 10 cases a year, or 20 cases a year, then the law doesn't develop quickly enough in the ways that it should to cater changes in social norms and society. So I think the doctrine of precedent works. I am not certain I'd answer that question the same in 10 years. We'll have to see, but at the moment I think it's the best we've got.
Thank you. Well, I know everyone will want to join me in thanking Sir Geoffrey for what's been a really stimulating lecture. I think he's talked for long enough, or we ought to give him a break now. But I hope you'll join me in thanking him in the conventional way. Thank you so much.